Do I need to hit continue? Oh, it asked me to approve the recording.
Oh, is that right?
Yeah.
Okay. Okay, hi everyone, welcome. So, good morning. My name is Petra Deeter. I'm from Victim to Hero Institute. And today we're going to be talking about the legal fight when it comes to parental alienation cases. I know that for a lot of parents, you don't want to drag this through courts, but unfortunately, a lot of the time it's not even your choice. Sometimes you don't even have the option. And for a lot of cases, if you don't fight in court, you don't have a way of accessing your children, a way of getting your children, a way of protecting your children. So unfortunately, it's not a fun topic, but it's a topic that is very, very important, and it's a topic that we have to address. Now, today we have with us a very important person that we really honor to have. We have with us attorney Michael Hiller. He is a Texas board certified family lawyer who has over 30 years of legal experience handling all kind of family law cases. And specifically, he can handle high conflict divorce and custody cases, and including parental alienation cases. And as we talk about, not all parental alienation cases are high conflict cases, even though from the outside it seems that way, because we want to clarify this, because we don't want a lot of the time it's not you that create the conflict. It's not, when you say high conflict cases, people tend to think that there's two people that are both high conflict, but a lot of the parental alienation cases is actually just one party that create the conflict, and then you get dragged along because of that. So we wanted to just clarify that, and we wanted to let you know that we do understand. But anyway, so Michael has a lot of experience dealing with this, and he's actually been ranked one of the top 1% lawyers in the nation by the National Association of Distinguished Counsel. So anyway, thank you so much for being here. We really appreciate you for being here. So if parents, if you are watching, could you please help us by, liking this video and sharing it? I know that some of you are not comfortable sharing it on your personal page, but if you could share it on the groups that you are in, and also let us know if you can actually hear us properly, you can see us properly. I'm not home. You probably could tell my background is a little bit different. So I'm on the road. Hi, Mary. Thank you so much. I could see you in the chat room. Mary's calling in from Ontario in Canada. Now, so Michael practiced in Texas, but a lot of the things that we're going to be talking about today, obviously, is going to be specific to Texas, but we are also going to talk a lot about strategy levels. So it's going to apply to a lot of places. So hopefully you can actually take what we are talking about today and put it into your specific jurisdiction. Obviously, we are going to look for lawyers everywhere to interview, so we hopefully will cover your jurisdiction. Hi, Claudia. Thank you so much. And Nikki, thank you. Hi, everyone. Yes, thank you so much for being here. And I know that Rachel is watching as well, so a lot of people in my team are here, so thank you so much. Anyway, so Michael, thank you so much for being here. Really appreciate you.
Oh, you're welcome. I'm glad to be here.
Yeah, so today we had a kind of a pre-discussion, a brief discussion, but we as you know, I have a lot of questions for you, and so why don't we start this from way before, way before um, the situation happened, right, way even before the children are born. So
Right.
let's talk about starting of the relationship, right? Let's talk about prenup before you even getting involved with someone, before the children are conceived. Okay, just let's talk about prenup. Is there anything in the prenup that you could potentially put together that hopefully protecting any custody situation later?
Well, Petra, I really like that question because a lot of attorneys, Texas attorneys who otherwise are good attorneys, they don't really understand the law there. And I think it's partly because how many prenups does someone do? There are lots of family law attorneys who can go their whole career and just do a handful. And I think one year, I don't know, I did like 20. And so it just depends on your reputation. But the only thing in Texas that you can't put about children in a prenup or postnup technically they're called marital agreements and premarital agreements. But the only thing you can't put in there is anything that negatively impacts child support. That's the only thing in the family code that says anything about children one way or the other. So the rule is you can agree to anything that isn't against public policy or illegal. So that means that in public policy is just things that are generally frowned upon, right? Um, so you can kind of use your imagination there. So you wouldn't want to put something in that everyone kind of knows is not good for children, but isn't necessarily illegal. But anything else, you could put in what the custody arrangement is, you couldn't put child support because it might negatively impact, but you could put your conservatorship, we call it joint managed conservatorship in Texas, or sole, which hopefully you don't have sole managing conservatorship. So other people might say joint custody or sole custody, but anything you want to put in, we call it possession in Texas. We have some strange words. Children are not objects, but we have our parenting time, it's called possession. I know you know that, Petra. But anyway, yeah, so you could put anything in there. The issue really isn't that you can or can't. The issue is if a child isn't born yet or isn't even conceived or you're not married, let's say all the above, how do you know what's in the child's best interest? Look, we could talk all day about a lot of this. I know we want to stay focused. So the point is that if it's a child that's not born, you don't know what that child's needs are. They could have special needs. It could be any situation possible. So you kind of want to keep that in mind. I would be more interested in not laying out a lot of specifics, but laying out what you're going to do at the time. How are you going to handle it? Most of my prenups historically have had binding arbitration clauses. I don't know if that's good or bad, but at least you know it's going to be something where it keeps litigation under control. So I'd be more interested when it comes to parental alienation and high conflict to have some mechanism to deal with that if it came up, for example. So whether it's having a mental health professional who's qualified to assess the children and the family at the time, you could put that in. Some kind of intervention program, like there are a couple of people around here that do interventions early in cases before they become severe, say mild to moderate. That's when they come in. So I would be more interested in the mechanism, perhaps having a collaborative divorce agreement, that's how you're going to do the case at the time. Those types of things. I hope that makes sense to you.
Yeah, thank you so much. That's amazing. So, and actually, that is so helpful because a lot of the time people don't think about this up front, and then by the time you
Right.
get to it, because I mean, obviously, we all want to be able to marry for life, and
Right.
right? I mean, who want to walk into a relationship already planning for the divorce? So obviously, but unfortunately, that's the reality, especially with today's society. It's very real. The reality of a divorce is very real. So having that is really important. And I really appreciate you brought up about some of the factors that make it potentially invalid by having things that is illegal or things that to do with child support payment. But that's so interesting to know that you can actually put in an agreement to do with child custody or or
Right.
yeah, that's really interesting. And I just want to say hello to Stacy. She's in Vegas. Milad is from Canada. Brock is from New Hampshire. Christina is also from New Hampshire. Hi everyone, thank you so much for calling in. So yeah, so that's really interesting. So with Texas, you can actually put in things to do with custody agreement. So you could potentially put in joint custody. So that's great. And what you suggested, I thought is also amazing, is to discuss about how you can handle custody agreement
Right.
instead of the specific outcome of the custody agreement.
Right.
So you mentioned about binding arbitration. So let's just explain that in the layman terms for the audience. So that is essentially forcing the couple to go and negotiate instead of just having litigation. Is that right? Like instead of forcing this through the court system all the time, let's kind of go through arbitration. Could you explain that a bit? Yeah.
So there's a lot of most people by now have heard of mediation, right? So like I've been a mediator 30 years, but in Texas, we've had a statute about 25 years. So anyhow, but arbitration is something different. Arbitration has probably been around longer as a formal mechanism to resolve a case. Like the American Arbitration Association, it's been around as far as I can remember. So, and I come from a family of lawyers, so my memory of law goes back before I was born, if you will. So, and my mom was a therapist, by the way. I always tell people that, so they'll maybe that's why I might be a little different than a lot of lawyers, because I think I have very strong. I was brought up before the internet and all, cell phones and oh man, social media. I have children from 29 down to 14, so I really been brought up a second time, you might say. But what am I trying to say? I had those really strong influences from my parents, right? And but binding arbitration is when it's basically a private judge. So it has good and bad components. Now, what I've done, I like to do things differently. Okay, that's kind of one thing I'm known for. So binding arbitration is when you hire someone to decide your case. Often it's a retired judge, doesn't have to be. I put in there that at least the person should be board certified in family law in Texas, right? I put in where they should have been trained. I give a couple of different places. And on top of that, the binding arbitrator can make binding decisions. I don't love it, but I like it better than court. And the key is to pick the right mediator, right arbitrator. Now, right now, you know as well as I do, Petra, that am I pronouncing your name right? I know we haven't known each other long. Is it Petra or Petra?
It's Petra.
Okay, and I can call you Petra, right?
Yes, of course. Yes, thank you.
So, yeah, so we're in a crisis situation now in terms of the lack of knowledge among the judiciary and lawyers, even lawyers that are otherwise very knowledgeable, never mind if they promote too much litigation, but they don't understand parental alienation. They don't understand high conflict. They use these terms, but they have no idea what they're talking about. It's no offense. You can't learn this in 10 minutes for one thing, okay? And so, because it's nothing that's obvious. So you want an arbitrator that understands both high conflict and parental alienation. Like you said, they are not necessarily the same. I read an article not long ago where the therapist, the mental health professional writing the article literally said like 10 times, parental alienation is not high conflict. Parental alienation is not high, over and over again, because they can overlap, but you could actually have a complete absence of high conflict in parental alienation, right? So what am I saying? Really, the arbitrator or whoever you need someone in there or some mechanism like collaborative, divorce. But then what happens if you get stuck? The big issue with collaborative is if it breaks down, you have to go to court. So if you have someone with a personality disorder, invariably, I'm no psychologist. My mom may have been a therapist, but I can't assess these. But we usually see, once you learn about parental alienation, once you learn about high conflict personalities, which is another term, then you usually know someone with a personality disorder when you see them, because they have a certain pattern of behavior. So it's not that you're diagnosing what they have, you're diagnosing what they do. So you want an arbitrator who understands these issues, because on the surface, that person can be very charming, can look like they're the last person on earth to make trouble. They're friendly. In fact, the big problem, as you know, is that at least at the beginning, until you get a handle on things in a case, it's the target parent that looks like they're crazy, if you will, right? So because they're getting PTSD and they're mimicking a personality disorder themselves, but nothing can be further from the truth, right? So again, get an arbitrator who understands these issues. And one other thing, there is something new developing called collaborative mediation. So basically it takes an old idea very quickly. Collaborative divorce, you have to agree, at least in Texas. I think it's true in almost every state. You have to agree, except Colorado where they don't have it. And North Carolina has arbitration in collaborative divorce, but no other state, I don't think. Why is this important? If collaborative divorce breaks down, you have to go get lawyers, different lawyers, and go to court. You don't want that. So what you want, I think, is this new thing called collaborative mediation, which means you do everything as if it's collaborative divorce or collaborative law, but you don't sign under the Texas statute. I can only speak for Texas in this instance. So what does that mean? You have a mediator who's trained in all this, who works with you and your lawyers, and then you can still bring in an arbitrator if you don't agree. Because in collaborative divorce, get a little technical here. So let me just say it quickly, and we can talk about this another time. Collaborative mediation is a great option because you can have the best of both worlds. You can mimic collaborative divorce without being restricted by the statute. So you do everything the same, but you have a mediator run everything and you sign a different type of agreement. And if it breaks down, you can bring in that arbitrator. And the key is, again, having the mediator and the arbitrator be knowledgeable about these areas.
Thank you. And I wanted to mention to everyone that are watching, I start seeing really amazing question in the chat room. Please go ahead and add questions in. If there is not enough time today, I'm going to ask for Michael to come back, if that's okay, another time for us to pick up the rest of the questions. So feel free to post as many questions as you can. I do wanted to jump in with one question from Michael in the chat room, which is, I thought really a good question, is about what happened, for example, with his case, all three of his arbitration end up in an impasse. So what would you do then?
Okay, so I think, again, there's a confusion of terms.
Okay.
So arbitration is a term of art. You can have non-binding arbitration, but it's pretty much non-existent. So just think of arbitration as binding by a third party. I think this person is talking about mediation. Mediation absolutely can end up in an impasse because, in fact, that's one of the big problems with high conflict personalities and people who are alienating parents. They're very difficult to make agreements with. So, and they won't see your point of view. So it's almost guaranteed that your mediation is going to break down unless you're extremely lucky. There's so many factors, about their, the way they think. It's inflexible. It's their way or the highway, right? So it's not just that they're inflexible. They've got to have their way. And they'll never get tired of fighting, right? So there's all these factors that I'm sure many of you are familiar with. So that doesn't surprise me. That's why I like other methods like collaborative mediation, where you can bring in a binding arbitrator. Otherwise, you're stuck with whatever judge is in your jurisdiction. And you don't know if they know anything about this.
I see. Thank you. And what you just brought up is so true, in that a lot of the cases that we've noticed with parental alienation is that they will create conflict for the sake of conflict. So
100%.
even when it's on a matter that they agree on principle, they will disagree just because they need to have it.
100% right.
Right. So, I mean, normally, if you were still married and before all of this happened, they could, both of you might agree on, I don't know, particular type of sport activity that the kids would do or anything. But then, the kind of schooling, and then suddenly now because of this, just they have to win, they have to have conflict. So even though it's something that they agree with, they suddenly now don't agree. And so, yeah, like you said, mediation is really challenging when it comes to cases like this. So thank you so much. So Michael was asking about how do you pick the mediators and arbitrator, things like that. Do you have any tips or any suggestions?
So how do you pick a mediator or an arbitrator? Well, I think that's the hardest one because there just aren't many people. I mean, I've met only a handful of lawyers, even in Texas, and a very small handful that really understand the issues. It's not that I'm so great, it's that I've exposed myself to these ideas, to learning about it, to reading about it. I keep a book write one of the newest books about parental alienation and the law that came out earlier this year, right here on the bottom of my screen, so I can refer to it. So the key is not so much finding someone, because most of the time I say good luck. I know there are judges in the country who have learned about this, who've made rulings that clearly they've been educated about not only the subject, but what to do, right? Whether it's the 3 strikes you're out program or something similar, right? There are only certain things that work, that we know work, right? Treatments, we don't really know if they work, but we know certain things like taking the child away. After 3 times that they do something they're been told they can't do, right? The alienating parent. Hopefully all of you are familiar with that. But picking a mediator, picking an arbitrator, the key is education, right? We're trying to educate more and more judges about that. There's a psychologist and attorney mediator who are from Clear Lake. I probably don't want to say their names now just because I don't want to favor anyone, and we haven't officially made our plan. But one of them's moving to Austin, and so we plan to start contacting the judges here and the lawyers here to start educating people and to let them know this is very serious. This is child abuse, and so that's the key: educating the judges and mediators and arbitrators we have. And so I guess the best thing to do would be to interview them with your lawyer. Hopefully your lawyer understands these issues. That's the first step. If your lawyer doesn't get it, then you got a real problem. So, maybe a lot of you represent yourself. I know everybody who's ever come to me, unfortunately, has already spent a lot of money and been with lawyers that had no idea what they were doing in this area. And so the case is really messed up. And like I say, I'm trying to get out there earlier and get other lawyers educated to get these cases earlier so we can have more effect.
Yeah, I think you're absolutely spot on there. Is that the lack of awareness and the lack of understanding in this issue, that is throughout all level of the professional level. The judges, the lawyers, the therapists, all these people that are dealing with these cases and yet don't understand it and don't know what it is, don't know what they're looking at. And what you mentioned earlier, which is something we also talk about a lot, is that in these cases, alienated parents come across, as agitated and emotional and unstable because they are suffering from PTSD. Actually, it's way more than PTSD. It's a complex form of PTSD
Yes.
because they're losing something that is just the most precious to them, their children, and seeing the children suffering and they being attacked personally as a human being and as a parent. So they're dealing with all that. So they come across like somebody that's not reliable. While the alienators, the abuser, come across as, just outstanding parents, so polite, so confident, charming, right? All of these. So people don't know what they're looking at. So definitely education is definitely the biggest solution in the big picture, in the long term. But in the short run, yeah, for parents to pick out the right people that representing them, from lawyers to therapists to mediators to arbitrator to judges and things like that. All of these are really important. I think we kind of jump over to the end bit a little bit, but I wanted to go back a little bit
Okay.
again. So, we talk about prenup, which was way before you even have children. Now, let's talk about, let's say, that you're going through, and I see a lot of great questions in the chat room with Mary and Claudia and Molinia. We're going to definitely try to pick that up soon, you guys. Thank you so much for putting questions in there. But so we talk about prenups that you could potentially put a lot of things in to help if there's a situation of getting a divorce. But let's say you didn't have the prenup, and then now you're going through and you realize that, oh, I have to have a separation or a divorce. So now, but you don't know that you have a parental alienation situation yet, right? You just go, well, this relationship is not working. I'm going to have to get a divorce. So you just thought that you have a normal divorce. You're hoping that you could work with your ex spouse so that you could, co-parent your children. So you go in and you're trying to get a custody agreement together. What are some of the things that this is before you even realize you have a parental alienation situation. What are some of the things that you must have in a custody agreement to prevent parental alienation or prevent situation that could get really bad and ugly later on?
Okay. In fact, I did want to say one more thing about prenup, something that I do. I like to put it, most people won't do it, but I highly recommend it. I call them marriage booster clauses. So not just to protect the children, but to give your marriage a chance, because there's some research now that says that when you have a mild to moderate case of parental alienation, that it may not become severe if there's proper intervention. So why am I saying that? The point is that maybe your marriage has a chance before you even get to the divorce. And there's a very active movement, but it's still relatively small, called the Marriage and Relationship Education Movement, which I've been involved in. And anyway, long story short, you can put clauses in your prenup that say what you're going to do if you start having problems in the marriage. And I think it's great if people even just have a therapist that they go to when they have an issue they can't get over. So many people think, oh, a marriage counselor or therapist means they're afraid because that means their marriage is falling apart. But something in the prenup that says, what do you do when, even on a maintenance basis, to go every year to go visit a counselor, just to talk about whatever it is that is going on. Maybe you're doing everything right. Doubtful, but maybe you are, right? But
The
that's
relationship is perfect.
what?
The relationship is perfect.
Oh yeah, yeah. Well, anyway, so what are you asking me? You're asking me, what do you have to have in a custody agreement in order to protect yourself and protect the children from possible parental alienation down the road? Well, as most of you know by now, I would guess most of the time, parental alienation doesn't really start to show up until after the divorce. The theory being that the alienator, has this really difficult problem with being rejected. I suppose even if they file the divorce, there's something down deep they probably don't recognize, that it absolutely destroys them psychologically, and then they begin to act on this parental alienation and start going after the targeted parent. So how do you prevent that? Well, the only thing I know of is having an early intervention program, something in there that says if either one of you thinks something's going on, that you're going to have either an assessment of the whole family, right? You got to do both. I always think there's two children, but I have three. But so all the children, one or more, right? And both parents, right? So you can't leave out, this the biggest issue is how often you have judges say, oh yeah, but judges will send a child to therapy at least the first time in the blink of an eye. And they'll say, oh yeah, if you want to go parent A, go. But the other parent's not going to go, the alienating parent, and they're also not going to get the right kind of treatment. So you've got to have either an assessment by someone who knows what they're doing of everyone. In other words, agree in the custody arrangement that that's going to happen the moment either one of you thinks that's needed. So you have to have binding, very specific language. In Texas, we're known as a pleading state. I don't know where that name comes from, but we're known as a pleading state, which means every order we have has to be very specific, which is both good and bad. It means that you know exactly when you pick up your kid. I've seen from other states where I can't even figure out when they're supposed to see the kid. So here we know exactly, when your parenting time is. So you want to have something very specific in Texas, and I'd recommend that in any state, something very, even though I don't practice law there, and please don't take this as legal advice, but something very specific about having an assessment done by a mental health professional who knows what they're doing. The only other thing you could put in is to have an intervention or a diversion program. And again, I only know of one team that does that. At least it's my understanding, it's just not very little focus has really been on mild to moderate parental alienation, right? Where that, so there's a team that's starting to work with me, and that's where it's already been introduced in Southeast Texas, near Houston and in Houston to some extent. And we're planning on bringing it to Austin. So you could have something in there about an intervention or a diversion program, which would consist of some education as well as therapy if needed. So you'd have to get a little more specific there. Here's the thing, if you put in that it's going to be an assessment, then what? Suppose the assessor comes back and says, yes, you've got the beginnings of parental alienation. You don't have anything in there about what you're going to do. That's where it gets so difficult. I mean, I've heard lawyers speak and they talk about how expensive this is, how hard this is, litigation in this area. One extremely well-known litigator who's spoken nationally, whom I know personally, but I never heard him say one thing about what do you do? What's the treatment? That's what counts. If you can't have a treatment program, and I don't necessarily mean treating the person, because we know it's better if you do treat the alienating person, the alienating parent, but we don't know if it's going to work. But we do know that taking the children away a little bit at a time, and then ultimately resulting in supervised possession or supervised parenting time, that's going to work. You just can't leave that children, that you cannot leave the children with that parent as long as they're still alienating that child, right? So is that helpful?
Yeah, no, it's very helpful. And I mean, I even see in the chat room, Bobby's totally agree with you in terms of like, you have to get the evaluator, the assessment has to be from someone that really, you can't have a regular therapist there.
Absolutely not.
Right, you need someone who really actually understands parental alienation. So, like, totally helpful. And then the other part about, yeah, what is the outcome? Like once you've done the assessment, then what? Because we actually have seen a lot of parents where they went through litigation and they have evaluation, and then the outcome said, oh yeah, there's parental alienation, but the therapist or the evaluators were not comfortable to recommend the court to take the child away. But really, like you mentioned, and we talk about this a lot, is that when you, especially when you're dealing with the moderate to severe cases, you can't leave the children with the alienators. You can't have any access until some kind of intervention happens. So you have to take the child away from severe alienators
Right.
until you get some kind of treatment, and then like you said, some kind of step up program that come with supervised visits until things are good, and then you can go back to normal. So yeah, all of these are really helpful. And then the point that you said about specific, I think that is also so important, because if you don't have very specific time of what time and where and how the children's going to be picked up by whom, then it's very confusing. It leaves space for, obviously the abuser is going to always manipulate and the situation. So if you're not clear about anything, they're going to go and twist that into something that's going to be harmful for you. So definitely that's important. Yeah, go ahead if you wanted to add anything else.
Oh, if I wanted to add something else, yeah, I would just say that I really am excited about this program of early intervention. And if you can do it before the divorce, it's better. But it might be difficult to get someone to agree to that. So I do think, on the other hand, they may not realize there's often very little self-awareness, if any, on the part of an alienating parent, right? They generally don't know or understand what they're doing wrong. They usually think they're doing right? They're operating on a very subconscious level, if you will. And so they don't have that awareness to know there's a problem. So before the divorce would be a great time to have an intervention, to have a diversion into some education, and if therapy is needed, have that done. And that's what I'm trying to focus on right now with this program that we're planning on bringing to Austin. So if you could put something like that in there, And, we'll be having more announcements because very soon we plan to roll this out. And hopefully it can spread across the country, because apparently there's just not much being done in this area with the mild to moderate. I mean, it makes sense for therapists and psychologists who are studying this issue, right, and lawyers to some extent, to focus on the severe PA, right, severe parental alienation. I'm sure most people out there know that PA stands for that. So when you have severe PA, that's where the attention is. But again, what do you do? Now, the only thing you can do is, like you say, Petra, you've got to have a plan to start removing the child from the alienator slowly but surely until and unless they stop doing those kind of behaviors, which we all know it's probably not going to happen. I mean, I keep reading that there are treatments that work. So we'll see. I don't know how much evidence there is yet that the treatments work.
So on Saturday, parents, on Saturday, we're going to have an event where we're going to be interviewed Dr. Stanley Klewa. He has a lot of clinical experience in this. He's one of the pioneer experts in this field who published two books that were approved, that was published actually by the American Bar Association. So the first one is called Children Held Hostage, talking about parental alienation, brainwashing of the children, talking about, all different type and the levels and the activities and manifestation of the children behaviors and things like that. And then another book that he just published last year is called Parent-Child Reunification, which is really focusing on the solution, about fixing it. So this Saturday, we're going to be interviewing him specifically about solution. So from prevention to treatment, like Michael is talking about, like early prevention or mild to moderate cases, as well as moderate cases, as well as severe cases, as well as cases where children have now outgrown the system. So now children are adult and have severely gone and you don't have any contact at all. So we're going to ask him about all of these. So please do join us on Saturday. Now, so I thought it was so important what you brought up about, okay, you put in a clause that said, okay, if one of the parents thought that if there's something is up, you should be able to get assessment. Actually, even before we go into that, if we could just back up a little bit, I just remember.
Sure.
Both in the prenup and in the custody agreement, could you talk about what are some of the things that you put in that could, unintentionally you put in there that could somehow invalidate the custody agreement or invalidate the prenup that made it unenforceable? Are there things there that would be a big no-no that certainly invalidate the whole thing?
Well, okay. So again, we're talking about Texas, and so and most states, it's my understanding, have this best interest of the child concept, right? So it sounds wonderful, right? Best interest of the child, right? It just sounds, oh, well, what could be better? But when you start to look at it, what it does is give the judge unbelievable power to decide what's in your child's best interest. And it's a very, very, very subjective thing. And in Texas, the only way you overturn in an appellate case a judge's decision in this area is to show abuse of discretion. Well, that just means you made the wrong decision. So, which is very hard to prove. And the lies that get mixed up with the truth are just amazing in this area. So it's not so much that you're going to put something in the prenup that's going to cause it to be invalidated. If we're talking about the prenup, the question is, how are you going to connect the current situation where, there obviously are people who are, especially in today's world, they're pregnant, they've already had a child before they get married, but we're not talking about that situation. We're talking about no child even necessarily on the horizon, right? You've already decided you're not going to try, if you will, to have a baby for 5 years, right? And so let's say it's 10 years later before the child's born. In that case, the whole idea is you're putting in an agreement that you think is in the child's best interest. Now, between the parents, there's nothing wrong with talking about what you think is in the child's best interest, because that's the way it should be. That should be you as co-parents, hopefully, right? Knowing what's best for your child, because you know your child, right? Whether it's medical issues, physical issues, good, bad, and indifferent, right? You might have a child who's a great musician already, at 5 years old. It happens. Well, you might have one parent who thinks it's ridiculous and hates the piano. So the point is, you don't know what's in that child's best interest until they actually are born and start to get older, right? And so what am I trying to say? I think that it's not a question of invalidating the prenup. It's a question of what works. And so I would focus, if you want to put in, you're both going to have the child 50-50 and live close to each other. By the way, that's the only time I think you should have 50-50. Is if you live close together and don't have a lot of conflict, because the kid's going back and forth a lot. And I think it can work great if the two of you are mature, healthy psychologically, if you will. But I'm talking to the wrong audience. So that's probably not going to happen here. So that's, again, why you don't want to put too many specifics in the prenup. You want to put the mechanism by which you will establish the best interest at the time that, if, as, and when you get divorced, we like to say in the law, if, as, and when. So, or if and when at the very least. That's the key, right? To have, again, collaborative mediation is that great tool, with the agreement that if things break down, you will bring in a binding arbitrator, and you could put in educated and knowledgeable and distinguished and recognized as an expert in high conflict and parental alienation. I would get that specific, okay? I don't need, we don't really even have, we don't, for lawyers, I don't know of anything that says you now have the knowledge to do this kind of a case, right? We don't have that. In psychology, it's, again, peer recognition. I don't think, I know we have PASG, the organization, right? Parental Alienation Study Group, but and other ones that are starting to appear. But we need that. We need to have a certification body, right? And so ultimately we'll have those things. And if there is something I don't know about in the psychology world that certifies people other than being recognized as an expert. So we got to work with what we have now. Does that make sense?
Yeah, for sure. Yeah. Actually, so there's, I see this a couple of times in the chat room. Someone brought up about co-parenting dwellings. What do you think of that? It's preventing travel. So
Co-parenting what?
dwellings. So like you have a home where the children live there and the parents actually take turn to live there.
Oh,
What is
okay.
I mean,
What do I think of that?
yeah, I have thought about that, but I mean, I want to hear what you think.
Yeah, I've heard it. Yeah, I don't hear about that too often. I thought there's something, the word nest is often in there, right? But so definitely familiar with it. It just doesn't come up very often. For one thing, usually, I don't know if you have to have wealthy parents to do that. Maybe I'm way off base here, but you got to have really mature people who are healthy psychologically to do that, right? Because now the home is no longer the two of yours to live there. You're shuttling in and out. I don't have a problem with it, but it's got to work, right? So if that home is just I'd rather see you just live closer by and not be tied to the physical home. But again, it depends. If that's what the two of you think is healthy for the children, then by all means do it. I don't know what else to say. It definitely fits with, if you're going to have, if the person is suggesting a 50-50 equal parenting, I like to call it, that they're each in the home with the children, 50% more or less. It's never going to be exact, right? But real close. then that's similar to living across the street, down the street, in the same neighborhood, in the same school district. I think you've got to be close, because unless you live in a small town, where driving 20 miles is nothing. In Austin, where I live, and in Houston, where I still practice and have a place there too, traffic can be horrific. So going 20 miles, depending on where you are, can be an hour trip easily. So, kids going back and forth when they forget their equipment for sports, or their musical instrument, or their books, or the right shoes for the, whatever, for PE. So again, I have no problem with it.
Yeah, I like you said, I think the challenge here is you dealing with someone that is clearly not collaborative. So when you have a physical home to
Yeah,
share with, it's the potential breeding grounds for so much more
I
problems.
agree. If we're talking about in the context, because I'm a little confused by the question, because is this coming from a person who is dealing already with parental alienation? And
Yeah, they're just trying to understand if that could potentially be a solution.
I just think one of my clients I've been representing for years, and her ex-husband sues her every couple of years. He's what I call a harasser. I'm sure there's another more sophisticated name for it, but someone who just he really, the kids don't even like him. He's not alienating the kids against their mom. He just is. He's a narcissist, in my opinion. So he's just always trying to get back at mom any way he can. And so she and I were talking about this 50-50 presumption, because they keep suing and trying to get 50-50, and then they set jury cases, and then they drop it at the last minute. They cost my client a fortune, and it ends up in the same place. He quits at the last minute for a variety of reasons. But what we were talking about, 50-50 just isn't going to work with one home or near each other or whatever, if you're going to have a lot of conflict with the person, because it's going to be chaotic, right? Any chance, like you were saying, Petra, if you don't have a specific pickup and drop off place, and oh, by the way, I don't even like middle places. You might need that for security, like a McDonald's or grocery store or whatever, that's maybe in between you. But I have seen this over and over and over again. A high conflict personality will say, well, I'm running 15 minutes late. Can we meet at the HEB? That's a big store in Texas. Can we meet at Randall's? Another one, right? Kroger, whatever it is. McDonald's, everybody knows. Well, then they go to a different McDonald's on purpose, and they blame you, and it's awful. So I like the harassing parent, the alien parent, to come to your house, so there can be no confusion, right? But that's just the way I look at it. Hopefully that makes sense.
No, thank you. And then, okay, so let's talk about. Okay, we talk about the custody agreement before. So that is the thing. A lot of the alienated parents don't realize that they are victims of parental alienation until it's
Yes.
really too late. Really,
Yes.
there are signs, a lot of early signs, but you don't know what you're looking at. And you're dealing with the divorce, and you just think it's just stuff going on.
Yep.
But sometimes you see it and you're going, well, I'm being difficult. Maybe I should just kind of let that slide, and then one thing, and then another thing, and then, right? So a lot of the time they don't realize it until it's too late. But let's say now you kind of start to see this stuff going on. And a lot of people will say, oh, parents, you need to document. You need to document, document, document. Well, let's talk about documentation. How do you document? What kind of things do you document? And I know in Texas, for example, you're a one party when it comes to video and audio recording, like wire taping.
Right.
So, could you talk about documentation?
Okay. Um, so Doc, could you give me just a second? I have to do something. I'll be right back.
Okay, no problem. And hi, parents. I want to just take a moment and thank so many of you guys for asking questions. Really, really appreciate that, and for sharing this. I know that I haven't picked up all the questions out there, but please continue. And Mary, thank you so much for sharing. I see Bobby in the room. I saw Michael, Christina. Hi, and I saw. Let's see, a lot of questions. amazing question out there. I will try to make sure I pick up Mary, Molina. I know I saw Pamela and Carol earlier from Kenya. Okay, Michael, yeah, go ahead. Sorry.
Oh, no worries. I think it's great the way you recognize everyone and make it so personal, and you're so upbeat about all this. It's really, really wonderful to see. Um, so documentation. Of course, I'm thinking so much about your comments about they don't know what's happening to them, so they may not even know that they should document. Um, well, what I like to be a little bit old-fashioned in this area, and what do I mean by that? So as soon as the problems in relationships, the relationships start, I would start. I mean, I don't care where you initially put the notes, but I would, like what I do when I want to make sure something's on my phone where I can find it quickly. I know they got all these apps for this, but and I like apps, but I don't like all of them. What I like to do is take my text messages and send one to myself, right? Because no one else can send one to myself but me. So everything I need in there that's all I put in there, things that I want to remember, right? So I would start doing something like that. Anything you think of, I don't care how trivial, that seemed weird, put it down, right? And if I were the lawyer, I'm going to say that too, right? In any divorce. I get so many of these, I don't even have to tell them. They already know something crazy is going on. So I would do that. Now, when I say old-fashioned, what do I mean? Once you've done that, and maybe you put it on then you have a place that you put it on your computer, however you store things, where you keep things secret, like if you're still living in the same house, you do all that, of course, or on your phone, if you can keep it away from your spouse, if you're still living with them. But the thing that I like to do at some point, especially once the divorce gets started, is to transfer things to a big block calendar. And so what do I mean by that? Now, it's been a little weird the last year and a half with COVID, because I've been in the courtroom like 3 times. So it's all been by Zoom. So everything's electronic. But once things get back to normal, and I think for the most part, they will. So I'll say it the way I've always done it, and then we can figure out how do we do it in today's world. So these big block calendars are like these blotters. Like I'm looking at one, they're like yay big, right? They fit, you get them at Home Depot or what is it called? The other one, they bought each other, so they're now the same. Target, whatever's in your area. And so it should, and then you transfer things to the day something happened. And because when you go to court, this becomes a wonderful tool. And I've taken these and blown them up, or not blown them up, but laminated them and used them in evidence. It's called demonstrative evidence. And pretty soon the judge is writing on, because here's what happens. You're going to put down little things that happen. So if it's October 12th, now you've transferred to that day, and you're just writing in your own handwriting. Don't worry about how it looks at this point, because you're just trying to create this record. So you write problem with drop off, he or she did the following, and just quick couple notes. Now you may have, again, this gets a little complicated, because you may have written a whole lot more on your phone or wherever. But the key is to put something down that can trigger your memory that you can talk about, because ultimately you're going to have 2 calendars. You're going to have one calendar that has all this stuff on it that's happened. And, it might go on for a few years, and that's only 24 months. It's not that much. That's just two calendars, right? And you may not turn all of that into the demonstrative evidence to use in court, but it's going to help you because you're creating a timeline. And I just think it's great. But that doesn't necessarily work for everyone. And if you want to do it electronically, because that's the only way you can do it, you can find calendars online. And I don't mean like the Google calendars. It's got to somehow get bigger, right? Now, one of the calendars is going to be the stuff that happens. The other one is going to be possession schedules that you think either that have been ordered or you agree to, or that you would like to see happen, because that's the one that you're going to hand to the judge, and the judge is going to end up writing on that one like, well, he or she may not like what you put, but they're going to use it as kind of a base. I've won more custody cases that way just because it was convenient for the judge to use my calendar. And I've never seen another lawyer do this. So I don't know, it works. And that's one way you document. What do you document? Anything and everything that you think is remotely important. And the slightest thing. If you saw the person show up and they had a brown belt versus a black belt, not important, right? So I'm not talking going crazy on details, but again, any little thing, person that's always talked to you for 10 minutes, you're talking to them, they say nothing all of a sudden. That's different. Write it down. What's going on, right? They start yelling at you, obviously. So is that helpful?
Yeah, yeah, very, very helpful. Thank you. So what about, can we talk about the type of evidence is that is admissible in court and what's not?
Okay, this is big. During a divorce, it's a lot easier to get evidence because you live with this person and have lived with this person, presumably for some period of time. Therefore, everything they've said a lot of things to you, and everything they say you can repeat in court, right? It's an exception to the hearsay rule. And by the way, hearsay is pretty much the same across the country. I don't know about Canada. I heard you mention someone from Canada, but it's probably pretty similar there too. And so what does that mean? That means when you say something to your spouse or ex, you can repeat that in the courtroom because it's called admission by a party opponent, especially if it's against their interest, right? If they say something, well, as far as I'm concerned, you can just have the kids. You know, it may seem like a comment made out of anger, but you can still say it, right? So, all right, you just give me a second. I wanted to check something because I made a few notes on this. So let me make sure I understand the question exactly. What kind of evidence is admissible and what isn't, and how do you decide? How do you handle that? So again, the basic thing with the divorce is you're there, the kids are there, and it's a lot easier to get evidence. Once there's a separation, one of the big issues is now the kids are doing things and they're not in your presence. And then we have another thing. A lot of things, the kids, a lot of times, right, the children come back to you and say all this stuff. Well, mommy did this or daddy did that, or, that. And you want to go then repeat that in the courtroom. But we have something called, that's hearsay. Now, here's a huge problem that has nothing to do with the law, except that it's wrong. In other words, it's the opposite of what the law really is. We have exceptions to the hearsay rule. And they're very, very, very real. But judges, by and large, don't understand them at all. Okay, there's been one guy has been writing articles about the subject for years. In other words, if a kid runs into the house and shouts, "Daddy did blah, blah, blah," that's called an excited utterance, right? The point being that most people don't run in the house and say something happened unless it really did, unless that's how they saw it. So that's an exception to the hearsay rule. So you go into court and you say what the child just shouted at you 3 days ago, and the other lawyer goes, "Objection, hearsay." The judge says, "Sustain." And then you explain why it isn't. The judge says, "Sustain." Happens all the time. It's horrible. And it's especially difficult in parental alienation cases because, number one, they've usually hired a lawyer that's going to lie for them. And don't underestimate that. Many, many, many lawyers who are esteemed in their areas lie all the time, or they just don't. They're so lazy, quite frankly, they don't investigate the truth. And that's one of my huge pet peeves. It's a lot of work to bring out the truth, so to speak, right? You got to actually dig for it. You got to actually work for it. You try to prove that something's true as opposed to not true. But most people just don't care enough. So they take whatever their client says and, suddenly they run with it. So again, you want evidence that can be used in court and not rely on things that can't be used. So how do you get around that? So most states have something like an amicus. In Texas, we have something called an amicus, who's a person appointed to represent the child and represent their best interests. It's always a lawyer. most states have a guardian ad litem or something like that, which sometimes it doesn't have to be a lawyer usually. Again, I speak mostly for Texas, but can, be a therapist in Austin and Travis County where I live now and practice. We have guardian ad litems a lot. In Houston, Harris County, excuse me, not so much. In fact, very little, almost always an amicus. But whatever gets appointed in your jurisdiction, that person can bring those issues to court. They can bring what the child says somehow into court, right? But again, how well educated is this amicus or ad litem, right? Are they knowledgeable of these issues? PA and HC I call high conflict. So I can't tell you how important. I'm getting interviewed for a case with a big hearing tomorrow. Everything's been done wrong. The ad litem, sorry, yes, she's a guardian ad litem. She totally believes dad as I'm following him. There's no question that I say that I'm a pretty good judge of character. I could be wrong, but I'm 99% sure that my client's telling the truth. My wife's psychic. She rubbed off on me. Okay, she can read a person easily. And I don't think she's ever been wrong about someone's character. And so what am I saying? That she has been fooled by deals that were offered to her through previous lawyers, like dad is living in Dallas and he's never been to Austin, hardly been in the kid's life. All of a sudden he's moving to Austin, he wants 50-50 and she has to take it. So she was convinced to do that. And then apparently the pediatrician suspected physical and sexual abuse, but somehow the lawyer didn't get the evidence. They go to court. They try to say that this happened with no proof. Now everybody thinks mom is making all these things up. She withholds the child. CPS doesn't do anything. They say nothing happened. Now she looks like a liar. You see how things are getting worse and worse. And then her lawyer gives her bad advice. She tells her not to turn the kids back over. And the judge denied that motion. It was handled all wrong. Now they want her to have supervised. Everything is reversed. The ad litem is convinced that mom is crazy and is bad for the kid and that she should be supervised. I've never seen a case this messed up. Of course, I'll say that the next time too. So I'm sorry I'm getting a little bit off, but I'm giving you an example of why evidence is so important. And you've got to have that ad litem trained properly. This ad litem has no clue of what's going on. It's almost for sure parental alienation starting quite early. I mean, it's in the divorce phase. So is that helpful? I know I occasionally, especially when I get a little hungry, I'll get off track a little.
No. Really helpful. Thank you. Yes, I have so many questions, and I apologize. I do have a cutoff point today in about 20 minutes.
Right.
Yeah, but so I know that we're not going to be able to cover nearly even just. I mean, we discussed so many topics that need to be covered today, and I know we're not going to be able to cover all of that today. So I really hope that we can have you back soon to
Okay.
pick up more
No
of it.
worries.
Yeah, because we're not even going into litigation yet and all that kind of things. We barely touch anything. But I'm losing track of what I was trying to talk about. So okay, so we'll talk. Okay, so we talk about you talk about hearsay. You talk about having a guardian ad litem, and there's so many things about the guardian ad litem actually that a lot of the times or the amicus, a lot of the times they themselves fall for the alienator's charm,
Exactly.
right? And then so now you're in even worse situation than not having them. So there's that stuff. But just go back,
Absolutely.
yeah, going back to the documentation and evidence. Um, I don't know about Texas, but for example, in California, it's very difficult to get video evidence admitted. How is that in Texas? And is there something that you do or not do in order for it to be able to get to court?
Well, we don't have, and I did look up a few of my notes on evidence that I wanted to, keeping records and so forth, and I'll get back to that in a second. But so we don't have a big issue with using video here. That's not the issue. The issue is that the judges don't like you recording the kids. So, you know, we got all these, what I would call pseudo or phony protections for children, right? We'd say we have these rules, never talk to the kids about the litigation. Well, you know, I agree with that in general. Protect the kids from what are adult problems. But when stuff like this starts to happen, I just don't agree. I mean, yeah, you got to be careful. You don't want to come home and tell the child everything that's going on, but they may need to know a little bit. Now, that's where the mental health professionals come in, because they can help you figure out how to say these things. And fortunately, even though you may have been ordered not to discuss litigation, you got to be careful with this. But if you're in therapy, you can probably have it discussed in a different way. So it's more not about the litigation, but about what's going on with both of the parents and the children. So so we don't. That's where the problem is. Like I had one where apparently dad had and I just tried this case, and fortunately mom was able to keep custody, but the judge did not recognize parental alienation at all. I had a wonderful expert. She got accepted. She testified everything perfectly. And so the judge gave my client custody, but didn't do anything for the parental alienation. Part of the problem was they spent, and I kid you not, $750,000 before they even came to their last two lawyers. And none of the lawyers had a clue of what they were doing. So they were just continue to litigate and litigate and motion that was going nowhere. And so that's their whole, all their money. Whatever they had left in the house was going to have to go to pay debts that they accumulated to pay their lawyers, and God knows.
That's
So,
insane. And we see that so much is parents go broke. And these are like, this should be the children college fund, the children, starting life fund. But yet both parents are throwing, it's crazy. We talk about parents that, used to have really good job and nice home, and now they become homeless because of this. We talk about, even we've even seen cases that they spend millions of dollars. I mean, we have executive, like C-level executives of public companies going through this, as victims and spending millions of dollars and still not getting children. It's so crazy talking about money. But I'm sorry, please continue.
yeah, it's a churning situation. But so it's not a problem with the video here. It's the fact that, but like I say, that particular dad videotaped my client all the time. She'd wake up in the morning, he'd be videotaping her. This was even when the marriage was supposedly okay. And so then it just got completely out of control after the, divorce was filed. And so she would try to videotape him or take a picture of his videotaping her. And it was just out of control. So the issues, so we don't have a problem with getting into evidence. We have a problem is keeping it under control. So, do you videotape the kids? Well, maybe a little bit. Do you videotape the other parent? They start doing something crazy. Yes, but what happens? They'll take out their video. We've had it where, they have that, what's it called? Like a ring system. Now a lot of people have video cameras outside their house, and people come in and they put tape over them. And so that they don't catch them doing bad things, even though that's why they're there in the first place. I mean, it just gets out of control. So I don't know if there's a good way to handle videotaping of children or even the other parent, because maybe a little bit here and there, I would suggest you keep it to a minimum, and make sure that your jurisdiction can handle that and will allow that. So hopefully that makes a little sense. I wanted to say there are some things that people overlook, and I wrote this down last night. And so let's say education. So I have rarely found a case where both parents were heavily involved in the children's education, going to all the parent-teacher meetings and taking them to school, picking up from school, going to all their events, taking them to the doctor, so not just beyond education, medical, dental. Now it's changing, I know, but it's great to see both parents involved, right? I've always been very involved with my kids' lives, from coaching them that's one time I'll get tears in my eyes talking about my kids. Well, I've been very, very fortunate. So, I married the same woman for a long time, and and we have kids from 29 down to 14. But my wife has done most of those things. I mean, I've been involved, and I went to everything. I coached them in sports and on and on and on. But there are things that she's done that I haven't done. And part of this is his career as a lawyer. It's especially the way I do it. It's pretty much like a doctor. It's 24/7, right? I'll be up till, like last night, I was up till 3, getting ready for this, but doing another case too. So keep records of who's doing what, right? Keep records of nowadays, right? Especially during COVID, emails, nothing but emails with the teachers, right? So I get people suing for custody. They don't have one single email with a teacher. They can't show that they're complaining about my client, the way she's handling the kids during COVID. Did they do anything? No. I had a whole case tried against my client, just complaining about my client and that she's psychologically unfit. Not one single word about what his plan was to go forward for custody. Not one single piece of evidence that he ever got involved, because they had to be homeschooled essentially, right? A lot of kids, parents have, this has been so complicated. Parents have immune disorders, and so they couldn't even leave the house during COVID. The kids couldn't, they didn't let, they could bring that home. So many people didn't take this seriously. I don't want to get political, but to me, it's just a health issue. It has nothing to do with politics. I don't get all that. But what am I saying? Keep that information, because I guarantee it's very rare when both parents are equally involved in all this. What about friends? The biggest memory I have of all my kids, my 14-year-old is still around, but my older kids, and they were girls, so there are probably more sleepovers. Oh my God, at the other kids, I knew all their parents, and we were all friends, and all these kids, sometimes they would call us their second parents. It's amazing how this all starts to get swept under the rug, and who arranged all these play dates, and who knows the kids' friends and the parents of the kids and kids at the soccer games. So you see, there's so much that goes into this, and we tend to forget about it. So just because you're getting a divorce or you're divorced, you still have some normal life in you, much more than you realize. Is that helpful? I keep asking.
Yeah. It's very good. Thank you. Okay. So we were just talking about videos and what kind of evidence to keep. Very good. There's an unusual question in the chat room by Claudia, and I saw that. I wanted to ask her. I don't think, Claudia, I don't know if I understand your question correctly, but I'm just going to state it as what I saw. Is that she's asking, is it possible to have evidence enter after the final hearing?
Evidence after the final hearing. Well, it depends on why. If you didn't know about it, yes, but it's still difficult. It depends on how important, how damning it might be, right, toward, let's say, the other parent. So if you don't, this is probably true in every state, a motion for new trial, one of the main grounds is the discovery of new evidence, right? If you find out something that's been hidden, that you felt like maybe you knew that he was hitting one of the kids, or she was, there was some sexual contact with one of the children, or just anything that was either illegal and or inappropriate, right? And you've discovered that evidence. You may have known it was happening somehow, some way, but you didn't have the evidence, and then you discover it. Well, that's a grounds for a new trial. But they're very, very, very specific rules on new trials, right? And I think it matches the federal rules. So it's probably the same in every state. Within 30 days after I'm dropping out here. That's the one thing about this does tend to, let me fix it. You can file this motion for a new trial if you discover evidence after the final hearing. But it's better not to, right? It better be really good. That's not a threat. I'm just saying, I'm looking at it I know how judges are. And but if it's serious, right? One of the things we're doing, I've got a case in a small county around here where, I mean, the youngest is 17 years old. The parental alienation is severe. I didn't get the case until one of the kids was almost 18, and it's just that the judges there, they don't think you should ever tell a kid at 15, 16 or over, even if they should go see a parent. And now we got our third judge there. Don't ask me how that happened. Um, but the point is, we're planning on going to the press. You've got to pull out anything and everything you can think of if you can't get the judge to recognize what's happening, right? So there's just a lot of lazy judges and lawyers out there, and that's no offense to anybody, and I'm not naming names, but it's just a fact, right? Most people, look, I'd rather watch a movie, watch a sporting event, hang with my kids. So what I do is I have a daughter visiting right now from Chicago. So we had dinner last night together, and then I took a break, worked for a while. Then we have a hot tub in the back. So me and my wife and she and I were relaxing in it. And then I came back to work, right? She went to bed. So I worked till 3 a.m. So, and I'm not bragging. It's just what you have to do. You have to have the ability to stay awake, work harder, be dedicated. And we just don't have that enough, right? So, and how did I get on that? So you want to try to get that before. If you don't get it until after, there is something else you can do. You can wait till the case is final, which will be most of the time after 30 days after the order, the divorce decree is signed, and then file a modification, file an emergency motion. Anytime if we're talking about physical or sexual abuse, emotional abuse is, of course, what we're talking about. It's the underlying thing that we haven't even really mentioned today, because that's what's going on here. It's child abuse, but we haven't made the paradigm shift. Petra knows this better than anyone, right? In fact, you're on a board, I understand, just found out this morning at PASG with two of the two people who I'm probably going to name them before. It's just not official yet. I'm funny that way. But you know probably better than anyone that I know in terms of you're out there trying to get the legislators to recognize that something needs to change. We are not in the paradigm shift yet. And most of you out there, I'm sure, are smart enough to know what I'm talking about. It's like an earthquake underneath. We don't have that much in Texas, but I've been to California enough to know about earthquakes, right? I've even been in one. So we have to have a seismic shift. We're not there yet. Don't kid yourself. Do not think for a second that your judge, unless you have proof that judge understands the issues, that they do. They don't. Just assume they don't know anything about it. They're going to tell you they do. They don't. So the legislatures, I hear some good here and there. I don't know how many. Something happened good in Florida recently. I don't even know what it is. I know in Texas, we got a long way to go. So we're still waiting for that paradigm shift, but it's happening because of people like Petra going out there and working hard and raising money to influence legislatures. So again, when I get hungry, I get a little bit off track, but hopefully I'm talking about important things.
We'll let you go in a minute.
No, I'm fine.
Really,
It's okay. I keep tea and juice here. It kind of keeps me going.
And thank you so much for your support and encouragement there. It's so true, and it's very unfortunate. So, for example, Claudia in the chat room, who is in my team, and she's also in the Texas 2503 team. She and I actually had a meeting with Texas Supreme Court Children Commission, and they deal with child abuse. And when we talk about this, it's the same thing. They like, we deal with physical abuse, we deal with sexual abuse. This is to do with child custody and family court, and then we have to present it to them. We have to explain, we have to bring in evidence, and we present it to them, and we said, hey, this is child abuse, this is exactly child abuse. And they actually said to us, they're like, oh, you give us a lot to think about. This is a paradigm shift that you're trying to create, and it's challenging. And this is, we never looked at this as child abuse before. now that you talk about this, we're gonna take it and we're gonna try to like digest this information. So we're gonna try to follow up with them again soon. But really, we had that meeting, and like it's seriously, you could see it. They like we never saw this as child abuse before.
Right. Well, and I think that, and I'm going to say right here and now, this is no offense against parental alienation as a term, but you and I both know for a variety of reasons, one in particular, because of this parental alienation syndrome that was decided really wasn't a syndrome, blah, 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 who cares? The point is it's happening. Let's just start calling it child abuse. Let's not even call it emotional child abuse. Let's just say, this is child abuse. What are you talking about? Physical? No, but it's child abuse. Well, what are you talking about? Well, when this happens, that happens, and the other happens, it's child abuse. And just keep saying it. And one of our plans for this small county is to bring the press in. It's not that far from Houston, and to basically try to put the judge on the spot to say, okay, so you're going to allow child abuse to happen without doing anything about it? I mean, that's what's going to be needed until this paradigm shift happens. So if you're going to go back to court after with a modification, that's what we call it in Texas, right? I don't know what it's called other places, but after the divorce is final, come back for a modification. If that judge doesn't understand that this is child abuse, you're going to have to find a different way. And
yeah, it's so unfortunate because we were talking to the Supreme Court Children Commission, which is a federal funded organization right. to support the state to provide resources and education to the commissioners, which is the people that run the court system. And yet they don't recognize this as child abuse. How are they going to protect the children? It's insane. But anyway, okay, so we are literally got only a few minutes, so I'm gonna jump ahead. I know that we haven't covered anything about litigation, and I apologize to parents. We wanted this to be really in depth, and we knew that we're gonna run out of time, so we're definitely gonna try to schedule a time to come back for Michael to talk about the legal litigation side of things. But I wanted to ask about there's something that you mentioned in our meeting and earlier, and I wanted to ask at the time, and I forgot, was you mentioned there was a family code, and I think also you mentioned there might be a penal code too to do with family violence. Which one is that?
So you're talking about in Texas?
In Texas, yes.
Courts that deal only in family violence?
Yeah, is there a penal code or is there a family code?
Penal code. Yes, we were talking about that. And I don't have it handy. I said I would, but I did see it.
Okay.
So we do have, there are the words emotional abuse and in the penal code where it refers to child abuse. So it's a little unclear how far it has to go. I think that's the problem. It doesn't list if this happens, that happens, the other happens. But those words do occur.
Yeah.
Right?
Yeah.
So it's in there.
Maybe later I'll follow up with you for the specific. But this is exactly why our team and we collaborate with a lot of organizations. We are lobbying for the law to change. We working with legislators because we want to change the law to get this recognized as child abuse. We need to have solution for parents. So this is exactly why. Because and this is not going to be an easy. It's not going to be a fast process. It's going to be a very long process. We know this. This is because legislation is going to take a long time, and we changing people's mind. It takes time. So unfortunately, that's what we're working on. But I know that I send you so many questions about custody interference, about litigation, false allegations, CPS, jury trial. So there's so many questions that we still have to address. Could we talk maybe just quickly about communication with your ex? Because we're talking about document and evidence. So we have to be conscious that anything that you say and write to your ex is going to be considered, is going to potentially being used as evidence. So, and parents can get very emotional dealing with all these issues. So what advice do you have for parents to make sure that when they communicate with the other parent, to not potentially put them in a position that is not going to be good for them?
Okay, yeah, I did see that question and wrote a few things down. And so, and I can go a little bit longer. I know you have 12:30, which we're almost at, but I can't go too much longer because I have this emergency case. But and then my daughter's leaving. Okay, so give me about 30 seconds here. So when it comes to communicating with your ex, it's complicated. The first thing I would say is do not talk to them any more than you have to, unless you have a therapist who understands this area working with you. Okay. So there's a guy named Bill Eddy, y'all may know about the High Conflict Institute. I think he's in California. He's a lawyer and a therapist. I think anyone in this area like you, Petra, I'm sure you know him, and he's in your state. He writes a lot about high conflict personalities, and you shouldn't even try to have each other in the same room when you're working with them. But with if you're talking about the early intervention program, and by the way, that's with Mary Alvarez and Chris Turner are the psychologists and attorney mediators that I'm working with. I'll say their names to bring that program to Austin. And so the idea is that an early intervention, a diversion program where there is education, psychoeducation with both parents, and then therapy as needed, right? And then even something called a case manager. So when you have, if you're lucky enough to get something like that in your case, and we'll talk about, you know, can we bring this to the rest of the country? Maybe we can. But in the meantime, I would not talk to the other parent out loud any more than necessary unless you've got a program like this going on, because it's not going to go well. So do you want to write? Yes, but got to be careful. There's something that Bill Eddy developed called the BIF. It's a whole, there's BIF, B as in boy, I, F as in Frank, F as in Frank. Brief, informative, friendly, but firm. It's not hard to master this. You can go find a video, or you don't even have to read a whole book. It's very easy to learn. So when someone writes you all this stuff that you did, and I've seen parents, they write 12 pages back. Don't do that. You're going to write one paragraph, maybe two. It's going to be brief. And I mean brief, informative. That means almost completely factual, almost no opinion from you. Here's what happened. Here's what I want to have happen. But then you say something friendly. I'm not kidding. You got to say something. I hope you had a nice day. I hope blah, blah, blah happened. Maybe, you know, safe trip tomorrow. I don't care. You got to do that, but firm, right? This is where I'm going to pick them up because that's what our decree says. That's it. And then you say a little bit friendly and you keep it brief, you're done. So you got to be, I would master that. There's something he has called ear, empathy, attention, and respect. That's really hard to do because basically you're kissing their you know what. But that's the only way you can talk to people who have personality disorders. It's extremely difficult. That's why you want, once they're at this point, you want to have a therapist with you helping you. So that's it. Communicating and writing. Now, last thing, I would highly recommend something like, there's several different ones. Our Family Wizard is the most well-known one. OFW, Our Family Wizard. It was developed by a judge originally out of Minnesota. It's become much, much more. Most people have heard of it. You've probably heard of it, Petra. There are other ones that are a little, that one's $100 a year, so it's not horribly expensive, but if you spend $300,000 on legal fees, you probably can't afford it. I'm not kidding. You can apply for a scholarship. So use one of those because it has text, it has email, it has a calendar. It has, you can pay your medical support through it, you know, your exchange medical records, everything. And that way it also can go right to the judge when you're done. So it's all there. And so everyone has to be careful. So I recommend Talking Parents is another one. There's some more, but those are the most popular, at least here in Texas. So that's what I would say. Be very careful.
Yeah. So
Put stuff on social media. Do not. write on social media. Make everything private. But even if you do, you're going to have to disclose it in evidence. So just don't write anything. The best thing to do is shut your accounts down. It's that risky. They're going to use everything against you.
Yeah, unfortunately. Um, yeah, so I just wanted to mention OFW and Talking Parents. So those are actually court approved. The
Yeah.
communication that going there, so you can
Yes.
actually bring it to court safely.
Yes. I haven't
And
had a judge that doesn't like them. Not in years.
right, exactly. So, that's a good way of communication and keeping track of records. I also want to mention that one of the person in our team, Chris, did a video. Like I actually did a video quite a while ago, like a few months ago, talking about how you can use the ads. How to structure it and how you can. So that way, it can help you later on when you use it as evidence. So, if you did not attend that event, you can find that video in the video tab on our Facebook page, Victim to Hero Facebook page. So you go to Victim to Hero Facebook page and go to the video tab, and you probably can find it there. Our family visit, OFW, or maybe it's Talking Parent. I don't remember which one it was, but one of them.
Yeah.
And it's applied to both how, what kind of information you should have there. And even when the other parent does not respond, it's still a very useful tool to use to
Right.
document it. So Michael, thank you so much. I am completely out of time. So, but I really
Well,
appreciate this, and I apologize to parents that we have hardly even covered. But you understand, this is a very big topic. It's huge, and there's so much to cover. So I really hope that we get you back soon, Michael, and then we can go more into the litigation side. We can talk about custody interference. We can talk about appeal and all that kind of things. And especially in Texas, because you have jury trial as well, which is another challenge when it comes to
yes.
litigation. So thank you
Yeah.
so much. Yeah.
Yeah. I'll definitely come back. I wish I could see all of you out there. I can't. So, and as far as not trying to promote myself too much, but if you're in another jurisdiction, most states allow you to bring in lawyers from other states as long as you have a lawyer in that state that's licensed. So, if you need that, let me know.
Yeah, so yeah, you can have a counsel. So Michael, I will send a link of this video to you so you can see. I mean, right now there's 100 comment or questions in the chat, so there's a lot there for you to check out the kind of question or things that people bring up. Parents,
Good.
please feel free to put more question and comment because, like I said, Michael's gonna come back. We're gonna try to pick up from here on. So if you have any question or comment, feel free to put it in there so that we don't miss it for next time. And then. Yeah, I hope to see you guys soon. Please share this, please like this, and please join our mailing list on our website, victimtohero.com.